So thank you for being here tonight, and I'm very excited that you're here. I have no presumption about where you fall on this issue, but I think it's good that we're here, especially at this point where we are 40 years into what even those experts who like the outcome call a judicially created regime related to abortion. So what I'm very excited about is that Clarke Forsyth, who is senior counsel for Americans United for Life and therefore has a particular perspective, but also a very talented lawyer, he has done the hard work of reading. No, you have to sit. Thank you. You don't have to sit on the front row. I'll do that. So, okay. But he's done the hard work of reading all the private papers of the justices and actually thinking about why the court arrived at the conclusion that they did. And that's literally thousands of pages. And so I'm very grateful that he has been willing to come in pre-publication and share with us what he learned in reading that. I should also note that Clarke is one of the probably top 5 lawyers in the country on this issue. We met 20 years ago in preschool, but we met 20 years ago on these issues as we litigated them, whether it's the state constitutional right, as we have in Minnesota, Doe versus Gomez, or the U.S. constitutional right. So he really is one of the lawyers who is most familiar, having been a part of the history as well as a student of history on this issue. So I'm extremely grateful that Americans United for Life gave him the opportunity to come here and join us. And so I'm excited to know what he has to say. Thank you for being here.
Well, thank you, Teresa, for a very kind introduction, and thank you all for coming tonight. We're here tonight to talk about one of the most iconic Supreme Court decisions ever delivered by the Supreme Court. And the 40th anniversary comes next week. And 40 years after the court's original decisions in Roe versus Wade and Doe versus Bolton, they remain intensely controversial. In fact, I think by several objective factors, the years of the controversy, number of test cases in the courts, number of constitutional amendments in Congress trying to overturn the decision, the focus of election campaigns, the opposition of one major party over 40 years. By these objective measures, I think that Roe versus Wade is the most controversial Supreme Court decision since Dred Scott in 1857, which struck down Congress's power to limit slavery in the Western territories and heightened North-South tensions leading up to the Civil War. But 40 years after the decision, I think that many people seem to be tempted to say, what's left to say about this decision? I mean, is there anything really? It's been 40 years. Is there really anything left to say about this? And yet I think we can't really understand the Roe versus Wade decision unless we look into the deliberation that went into the decision. And I say that because the deliberations, what happened in the Supreme Court, was really the whole ballgame, because there was no evidentiary record in the lower courts, and what the justices did was really based upon their own experiences and hunches and feelings about the issue. And so my book, Abuse of Discretion, The Inside Story of the Supreme Court's Creation of the Right to Abortion, tells that story and the continuing repercussions. And I wrote the book to really solve the puzzle of Roe versus Wade. Back in 2009, I looked at the website oyez.org, oyez.org. Some of you may be familiar with it, but it has all the, virtually all, I think, briefs and oral arguments and transcripts of the oral arguments of Supreme Court decisions going back to the 19th century, and the audio of the original arguments in Roe versus Wade, the transcripts are there. But the audio of Doe versus Bolton, the companion case, is there, but not the transcripts. And I was wondering how it happened, how the court decided the case, what was argued. Why did the justices take two cases without any evidentiary record? What happened during the deliberations? Why did they reach such a sweeping result? And how could the Supreme Court issue a decision that created so much turmoil in public health and law and politics over the past 40 years? I mean, the 100,000 people that are going to be in Washington, D.C. next Friday marching aren't there because of Gideon or Miranda or Griswold or virtually any Warren Court decision of the 1960s. They're there because of Roe versus Wade. And yet, there have been some important developments over the last 20 years. Primarily, the release of the justices' papers, as Teresa mentioned. Justice Douglas's, William O. Douglas's, was released in 1980, but Justice Blackmun's was released in 2004. And little by little, as the years have gone by, more of the justices' papers have been released, and now at least 7 of the 9, except for Burgers and Rehnquist, have been released, and I understand Stanford has now opened some of the papers of Chief Justice Rehnquist. Chief Justice Burgers won't be released until 2025. But these are new sources of information, and I'm not the only scholar to look at these. David Garrow and others have looked at them. But I've had the opportunity, I think, to review more of the 9 than anyone else before, and it has been certainly eye-opening as to what was going on in the court. Before I go too far, I think it's important that we recognize that what we call Roe versus Wade, what we know as Roe versus Wade, is really 2 cases from 2 courts. Roe versus Wade from Texas and Doe versus Bolton from Georgia. And the 2 cases were argued together, they were decided together, and issued the same day. But the Doe decision has been relatively ignored over the last 40 years. I mean, if you look at anthologies of the cases, histories of the cases, you hear about Sarah Weddington and what happened in Roe versus Wade, but very little, if anything, is said about Doe versus Bolton. And you would be surprised to hear the audio of Dorothy Beasley, the Assistant Attorney General for Georgia, who represented Georgia in the Doe versus Bolton case, who I think clearly was the most articulate arguer of any lawyer before the court in either Roe or Doe. And if you go to the oea.org website, you can hear both of her oral arguments. She was an experienced Supreme Court practitioner. I think the second argument in Doe versus Bolton was her 5th before the Supreme Court, and she went on to an illustrious career, rose to be chief of the Court of Appeals in Georgia, and she was a tenacious arguer, very articulate, very quick on her feet, very bold, and she was really the best of all the attorneys before the Supreme Court, but you don't hear anything about her. So Roe has been commonly ignored. But the court said that Roe and Doe are to be read together. And in Roe, the court suggested that the states could prohibit abortion after fetal viability, and as they wrote, quote, except where it is necessary in appropriate medical judgment for the preservation of the life or health of the mother, unquote. But in Doe, the court added a significant health exception that is typically overlooked. And the justices defined health as, quote, all factors, physical, emotional, psychological, familial, and the woman's age, relevant to the well-being of the patient, unquote. So the way the justices defined health in the Doe case has proved critical, because health in abortion law, because of the Doe definition, basically means emotional well-being without limits. And so although the court said the states could prohibit abortion after fetal viability, the health exception swallowed the supposed ability of the states to prohibit abortion after fetal viability. And consequently, as Harvard law professor and comparative legal scholar Marianne Glendon has pointed out, quote, it was Doe that set the United States on a far more extreme course than that taken in most other liberal democracies, where the regulation of abortion has largely been left to be worked out through the ordinary democratic processes of bargaining, education, persuasion, and voting, unquote. So Roe and Doe together were sweeping decisions. They struck down virtually every abortion law across all 50 states. None were left standing after January 22nd, 1973. They've isolated the U.S. as one of only 12 or 14 nations to allow abortion after 14 weeks, and isolated the U.S. as one of only 4 nations out of 195 that allows abortion for virtually any reason after fetal viability. So the U.S. with North Korea and China and Canada is one of only 4 nations that allows abortion for virtually any reason after fetal viability. That's still the law today. There may be marginal regulations around the right, and there may be state attempts to pass limits, like Arizona has attempted to pass a 20-week limit on abortion, but they have been challenged in court, at least Arizona's has, as violative of Roe versus Wade or in conflict with Roe versus Wade. Well, one of the surprising things I found in my research into the justices' papers is that Roe really began as a mistake. The justices decided to hear the cases in April 1971 under the misapprehension, to use Justice Blackmun's words, that the cases only dealt with jurisdictional questions between state and federal courts, pretty obscure legal questions. And they chose 2 cases, Roe from Texas and Doe from Georgia, that had no trial and no evidentiary record about abortion or its medical or sociological implications. So the justices took these 2 cases in April of '71 to apply Younger versus Harris. Younger had been a divisive case that had been argued 3 times before it was finally decided in February '71, just 60 days before the justices took Roe and Doe. And they took Roe and Doe to decide whether this Younger case that they had just decided applied to the factual scenarios in Roe and Doe. And Justice Blackmun related this story to at least 2 people, and it's confirmed by the briefs in the abortion cases, the justices' papers, and the oral arguments. And in a letter to Chief Justice Rehnquist in 1987, Blackmun described what happened. He said, quote, "I remember that the old chief," referring to Warren Burger, "appointed a screening committee chaired by Potter Stewart, Justice Potter Stewart, to select those cases that could, it was assumed, be adequately heard by a court of 7. I was on that little committee, and we did not do a good job. Potter Stewart pressed for Roe versus Wade and Doe versus Bolton to be heard, and did so in the misapprehension that they involved nothing more than an application of Younger versus Harris. How wrong we were," unquote. Now, it's not surprising that they took these 2 cases with no evidentiary record on abortion or its implications, while Justice Black and Harlan were still on the court in April 1971, if their purpose was just to address these state federal procedural rules. Because here's what the scenario was. Younger had limited federal court interference in pending state criminal prosecutions, meaning if a state court defendant had been charged with, say, violating trespass laws, could that state court defendant take his case out of state court and into federal court, thinking that the federal court would grant him greater rights? And that was the kind of scenario that was at issue in Roe and Doe if you're just looking at procedure, because a doctor in Roe and Doe, one of the potential plaintiffs, could have been charged or indicted for an abortion under state law in state court, and could he take that case out of state court and into federal court? So it was just sheer procedure. And if you're deciding, can a state court defendant take his case out of state court and take it into federal court, you don't need an evidentiary record on abortion or its medical or sociological implications. Those are just the underlying facts of the bigger procedural rules. So that's why Younger was relevant, and that scenario was present in many of the abortion cases that was in federal court. So they took the cases to address state federal jurisdictional questions without any evidentiary record, but ended up using the cases to address a full-blown right to abortion. despite the fact that there wasn't any trial or any evidence on abortion or its implications. In fact, Sarah Weddington tells this very interesting story about what went on in Texas, in Dallas, Texas, when she first stood up to argue Roe versus Wade in Dallas on the afternoon of Friday, May 22nd, 1970. And at the time, she faced 3 federal judges. It was a special procedural rule where you would argue between 3 federal judges rather than just one. One of these judges was Sarah Hughes. Hughes had lobbied the Texas legislature to repeal the Texas abortion law, and Hughes was eager to eliminate the abortion laws, as she frankly admitted to a number of interviewers later. But Sarah Weddington, a couple of years later, told a dinner audience that, quote, "At one point during the hearing, when my nervousness was obviously showing, Sarah winked at me as if to say, 'It's going to be all right.' And sure enough, it was." And so the judges decided they didn't need to hear any facts or witnesses, and they conducted an oral hearing that just lasted 2 hours, mostly on procedural and jurisdictional issues, like Younger. Despite the implications for the abortion laws of the for all 50 states, they struck down the laws, and the cases went straight up to the Supreme Court. So no factual record was created, ironically, by either the court in Texas or the court in Georgia, and because of the federal laws in effect in 1970, there was no intermediate appellate review by the federal appeals court. These 2 cases went straight up to the Supreme Court, and it was pretty quick. The court was faced with deciding to hear these cases in the fall of 1970. So here's just one example of why no record turned out to be very important. Mary Doe, the Doe in Doe versus Bolton in the Atlanta case, she never had an abortion. Just before the hearing in federal court in Atlanta in 1970, she felt her baby kick. Her pregnancy was that far along. And she told her counsel, Margie Pitts-Hames, that she no longer wanted an abortion. She wanted out. But because there was no record, no factual record in the case, Hames was later able to tell the justices in oral argument before the Supreme Court that Mary Doe had been denied an abortion. And the fact that she had wanted out entirely and no longer wanted abortion was never told to the justices, and this came out in interviews years later. Now, some think that Roe and Doe were inevitable, but the evidence seems to show, on the contrary, that they were accidents, the result of a unique moment in U.S. history and in the court's history. And one of those decisive moments came in September 71 with the abrupt retirements of Justice Hugo Black and Justice John Marshall Harlan 3 months before the first arguments. So between April 71, when they took these 2 cases, and December of 71, when they first had heard oral arguments, Justices Black and Harlan abruptly resigned because of ill health, and the court was then faced with really a crisis and an unusual situation of 2 vacancies at the same time. Black and Harlan were literally deathly ill. Black died a week later, and Harlan died 3 months later. So for 15 weeks, from September 71 until January 72, when Justices Powell and Rehnquist were sworn in, the court had 7 justices. And those 2 vacancies completely flipped the balance of the court and created a 4-3 block of justices, Douglas and Brennan and Marshall and Stewart, who sat for the first round of oral arguments and were really bent on eliminating the abortion laws. In fact, Bernard Schwartz, who a late professor at NYU, a former ACLU counsel, says that Douglas and Brennan, quote, led the pro-abortion bloc at the first conference after the first arguments in December of 1971. So Roe and Doe were first heard only before 7 justices on Monday, December 13th, 71, and then they met in conference on Thursday, December 16th, 71, and they settled the procedural issues, said Younger doesn't apply here, and then they might have considered dismissing the cases and looking for cases with an evidentiary record. But the four-judge majority of those 7, Douglas, Brennan, Stewart, and Marshall, decided to use the cases anyhow to eliminate the abortion laws. and to move ahead as quickly as possible. So Roe and Doe really began as a procedural mistake that left the justices without any evidentiary record to consider the complex historical and legal and medical and sociological issues that they would quickly get into. And though this oversight as to no evidentiary record may seem minor, it really was a blunder that skewed the justices' consideration of abortion over the next 13 months. The justices quite clearly filled the evidentiary vacuum with their own experiences and hunches and thoughts and surmises about these issues. And by brushing aside these procedural questions and deciding the issue without any evidentiary record, they really stumbled into 40 years of enduring controversy. So Roe was very much a result-driven decision by a temporary majority of 4 justices and might never have happened without the happenstance and the historical curiosity of a double vacancy after the abrupt retirements of Black and Harlan. And the oral arguments didn't help. I mean, the oral arguments were simply atrocious. To give you just one example, the attorney for Texas, an assistant state's attorney, assistant attorney general, apparently never argued before the Supreme Court before, stands up before the justices in the very first oral argument. And his first comments to the justices, facing Sarah Weddington and Linda Coffey off to his left, who had just finished arguing, he stands up and tells the justices, well, it's an old story, but when you argue against 2 beautiful women, a man is sure to lose. And that's how he started off his oral argument in Roe versus Wade. If you go to oyez.org, you can hear that. And the argument went straight down from there. The arguments were terrible in the cases. And only Dorothy Beasley for Georgia really mounted a very intelligent and vibrant and strong defense of the Georgia law. Now, another drama underlying the surface was the struggle between Chief Justice Warren Burger and Justices Douglas and Brennan and Stewart, who exhibited suspicion and sometimes outright hatred of Burger during the first few years after Burger had been appointed Chief Justice by President Nixon in 1969. And there are several instances that are shown in the papers in 1971 and 72 where Douglas and Brennan and Stewart applied pressure, sometimes subtle, sometimes strong, to get the abortion cases decided and the abortion laws eliminated. After the justices met in conference on Thursday, December 16th to vote, for example, a major disagreement arose as to exactly how the 7 justices had voted. There was confusion between the justices as to exactly what the vote had been. And this was crucial because among the 7, if Chief Justice Burger was in the majority of 4 or 5, he would assign the opinion, but if he was in the minority, then Justice Douglas, who was the senior justice, would have assigned the opinion. And so Burger goes ahead and assigns the opinion to the justice with the youngest tenure on the court, who at that time was Harry Blackmun, who had just been on the court for 15 months. But the next day, one of Douglas's clerks gave him a memo contending that Burger had wrongly assigned the opinion because he was in the minority. And although Douglas protested in a letter to Burger, Blackmun kept the opinion assignment. So that's how Blackmun became the justice who wrote Roe versus Wade and Doe versus Bolton. And because he's the named author, he's the one most visibly associated over the past 40 years with the decision. But they really are as much the responsibility of Justices Douglas and Brennan as they are of Justice Blackmun. And I think this is demonstrated by some additional facts. If you have a chance to look at the 2010 biography of Justice Brennan, entitled Justice Brennan, Liberal Champion by Seth Stern and Stephen Vermeil, they suggest just how extensive a role Brennan had. They write, quote, "In fact, Brennan worked so quietly that for some time it remained difficult to determine exactly how influential a role he played." And in the private 72-73 volume of Brennan's opinions, his clerks annually assembled a separate bound volume of Brennan's written opinions that he could consult and use privately. But they included, in that year, they included Roe versus Wade and Doe versus Bolton, even though Brennan wasn't the named author. And they wrote, quote, "Brennan felt a strong enough sense of ownership in the Roe and Doe opinions that his clerks included them in the bound volume of his opinions for that term that Brennan maintained for his own use. The accompanying note explained that the opinions, quote, were substantially revised in response to suggestions made by Justice Brennan." And I think in reality, that was a big understatement. Brennan had a huge impact on the decision. And one of the most haunting stories that I really uncovered is that of a law student by the name of Bill Maladin. Bill Maladin was chief editor of the Notre Dame Law Review. He was the valedictorian #1 in his class. He interviewed with Justice White and Justice Brennan for a Supreme Court clerkship. He ends up going with Justice Brennan, and he landed at the Supreme Court after graduating from Notre Dame Law School in July of 1972. And before he had graduated, he wrote an article which was eventually cited in the Roe versus Wade and Doe versus Bolton opinions. And it was an article which surveyed basically all of legal history in property law, tort law, criminal law, showing the progressive growth of legal protection for the unborn child. He writes and publishes this, and then he lands at the Supreme Court and finds out that his boss is the leader of the block of justices that is about to strike down the abortion laws. And he was there at the second oral argument in October of 1972, but as he told me, it was clear that he was only there to sit and listen about how the opinions should be edited because the outcome was foreordained. And obviously, because of what he had written before becoming a clerk, and because of who his justice was, he felt an extraordinary degree of tension in working for Justice Brennan and helping the process move forward until the opinions were released in January 1973. In May of 72, a crisis, a very unusual crisis, erupted in the Supreme Court over the Roe versus Wade and Doe versus Bolton opinions. Justice Blackmun was assigned the cases in December of 71. He spent 4 or 5 months working on writing the opinions, and in May of 72, he distributes drafts of the Roe and Doe opinions to the other justices, soliciting comments and soliciting their vote in the case. And Chief Justice Berger then renewed a motion he had made to reschedule Roe and Doe for re-argument in the fall. Justices Douglas and Brennan and Marshall and Stewart immediately opposed re-argument because they wanted the opinions released and the case and the laws struck down before the summer of 72. And the intensity of Douglas and Brennan and Stewart to eliminate the laws without re-argument, which would have allowed Justices Powell and Rehnquist, the new justices, to sit and potentially vote and potentially change the outcome, is reflected in a handwritten note to Justice Douglas, which is in Douglas's papers. Brennan slipped this to Douglas perhaps around June 1 of 1972, and here's what he wrote to Douglas. Brennan wrote, quote, "I'll be goddamned. At lunch today, Potter Stewart expressed his outrage at the high-handed way things are going, particularly the assumption that a single justice, if CJ, meaning Chief Justice Berger, can order things his own way, and that he can hold up for 9 anything he chooses, even if the rest of us are ready to bring down 4 threes, for example. He also, meaning Stewart, also told me that he resents CJ's confidence that he has Powell and Rehnquist in his pocket. Potter wants to make an issue of these things. Perhaps fur will fly this afternoon," unquote. And I think this note captures the tension that was at stake in the court. And in fact, Douglas had written a draft dissent if the court decided to go ahead and schedule the cases for re-argument. That draft dissent is also in Douglas and Brennan's papers. Douglas delivered a protest letter to Berger and then sent Brennan a scorching dissent that he threatened to publish if the majority voted to rehear the cases. Brennan urged him to tone it down, and according to James Simon, who interviewed Blackmun in May 1991 for his book, The Center Holds, Douglas had a critical impact on Blackmun's vote at this time. Simon, in his interview with Blackmun, wrote the following. He said, quote, "Douglas refused to withdraw this dissent until Blackmun personally assured him that his position of declaring the abortion statutes unconstitutional was firm, and that he had no intention of reversing that position after re-argument. Blackmun gave Douglas that assurance. As it turned out, Justice Douglas was the biggest winner of all. His prolonged tantrum had produced a firm commitment from Justice Blackmun to hold to his original position of voting to strike down the Texas and Georgia statutes," unquote. So, although the 5 justices eventually agreed to the re-argument that happened then in October of 1972, there was considerable momentum towards striking the abortion laws, as Justice Powell later admitted, which proved irreversible. So even though Powell and Rehnquist sat for the second oral argument, the momentum was all toward eliminating the abortion laws, and the question only was, how are these opinions going to be written? So with no evidentiary record on abortion or its risks or implications in either Roe and Doe, the justices were left with a large vacuum and the temptation to rely upon their own personal experiences and hunches in deciding the abortion cases. And in that evidentiary vacuum, the 7 justices were susceptible to unprecedented, untested theories of law and medicine and history. And just to give you one example this evening, the outcome was really driven by a novel medical claim that abortion was safer than childbirth, despite the fact that there was no reliable medical data to support this in 1972. There was, of course, no record in the 2 cases, and so this claim, this medical claim, was argued in the briefs and at oral argument for the first time in the Supreme Court. But it was intensely disputed during the oral arguments, and no existing obstetrical textbook published before 1972 ever made such a claim. The claim was based on a mechanical comparison of maternal or childbirth mortality rates versus abortion mortality rates from the 1950s from Eastern European or Soviet bloc countries. But there was no reliable data that these rates were comparable in any way, or that they showed that abortion was safer than childbirth. But this proposition really drove the opinions and drove the result, shaped the justices' conception of the historical right to abortion, shaped their limitations of public health officials regulating the procedure, shaped the scope of the abortion right they were writing and creating and designing. And if you read Doe and Roe versus Wade and Doe versus Bolton carefully, you see this underlying premise that abortion is safer than childbirth throughout both opinions. And it was decisive. And the justices ended up citing 7 medical sources to support this claim, but none of them were peer-reviewed studies, just raw numbers. And several of these sources that are cited in the Roe versus Wade opinion and in Justice Douglas's concurrence in Doe versus Bolton really have no data whatsoever that is reliable. One was a letter to the editor. Another was just a report of an Eastern European conference on abortion in 1961. But none were peer-reviewed, and none really supported the proposition. But it was decisive to the outcome. In fact, after the Roe decision, Judge Henry J. Friendly, who is reputed to be the greatest federal judge in the 1960s and 1970s, never to make it to the Supreme Court, he criticized the court for this use of social science and medical materials that were simply not part of the record in the trial courts. Judge Friendly said, quote, "The main lesson I wish to draw from the abortion cases relates to procedure. the use of social data offered by the appellants and amici curiae for the first time in the Supreme Court itself. The court's conclusion in Roe that mortality rates for women undergoing early abortions appear to be as low or lower than rates for normal childbirth rested entirely on materials not of record in the trial court, and that conclusion constituted the underpinning for the holding that the asserted interest of the state in protecting women from an inherently hazardous procedure during the first trimester simply did not exist. So in other words, the reason why the justices prohibited any health or safety regulations in the first trimester was because of this assumption that abortion was safer than childbirth. And Judge Friendly goes on to say, if an administrative agency, even in a rulemaking proceeding, had used similar materials without having given the parties a fair opportunity to criticize or controvert them at the hearing stage, reversal would have come swiftly and inexorably. The court should set an example of proper procedure and not follow a course which it would condemn if pursued by any other tribunal. So Blackmun's assigned the opinions. He distributes them to the justices in May of 1972. But at that point, the scope of an abortion right that they were crafting was completely undefined. In other words, if there was an abortion right, should it be limited to the first month, the first 12 weeks, the first trimester, 20 weeks, up to fetal viability, or extend throughout pregnancy? How would they define the scope of this abortion right? Well, the opinions that Blackmun distributed in May of 72 did not define the abortion right whatsoever. He simply wrote opinions that struck down the laws as unconstitutionally vague. And Brennan responds to these draft opinions by, in fact, confirming that the justices had only voted to strike down the laws subject to abortion being performed by a licensed physician within some time limit after conception, but that time limit was undefined. So the justices then voted to re-argue the cases, or rehear the cases, in October of 72. After that argument, Blackmun returns to drafting a second draft of the opinions, and he distributes a second draft in November of 72, which then emphasizes that the first trimester is going to be the decisive limit. And so he, in these second draft opinions, the abortion right he's creating only exists up to the end of the first trimester, 12 weeks. And he tells the justices in a cover memo, he says, "You will observe that I have concluded that the end of the first trimester is critical. This is arbitrary, but perhaps any other selected point, such as quickening or viability, is equally arbitrary." But then, after the second drafts are distributed, the justices begin to negotiate behind the scenes as to the scope of this right. And by early December of 72, Justices Powell and Marshall had persuaded Justice Blackmun to expand the right from 12 weeks, first trimester, all the way to 28 weeks, which at that time they thought was the edge of fetal viability. So they expanded the right 4 whole months, 16 whole weeks, without any evidentiary record as to the medical implications of this, potential risks, potential for live birth abortions. None of that was in the record. And so Blackmun's third draft of December 21, 1972, finally expanded the right to viability, and then with the Doe health exception, even farther. And so 1 month before the opinions are released, the justices have expanded the abortion right to viability without the benefit of any briefing or oral argument. Because in the 4 hours of argument, 2 hours in December of 71, 2 hours in October of 72, the word viability was never mentioned once. It was not briefed, it was not argued in 4 hours of oral argument. And the implications were never discussed before the justices started to write the opinions. And that's critical because it's what isolates the U.S. as one of only 4 nations that allows abortion for virtually any reason after fetal viability. That's why we're in the situation we are in today, and that's how the viability rule was created. Well, by issuing such a sweeping decision, the justices created several problems, and I just want to focus on a couple here tonight. But one of the problems created is that we have a public health vacuum. We've had a public health vacuum by prohibiting health and safety regulations in the first trimester when 90% are done. Roe versus Wade and Doe versus Bolton prohibited the states from enacting health and safety violations in the first trimester. And that was basically the rule until basically 2000, when two circuit courts first allowed the states to enact some clinic regulations. But even today, 40 years after the Roe and Doe decisions, the Supreme Court has never affirmed clinic regulations or any set of clinic regulations. And so they are still subject to the discretion of the federal courts today. Sandra Day O'Connor in 1983 recognized this when she wrote in the Akron decision that medical technology is changing, and this change will necessitate our continuing functioning as the nation's ex officio medical board with powers to approve or disapprove medical and operative practices and standards throughout the United States, unquote. So the court holds all the cards on this public health issue, but can't intervene like public health officials normally can. And this has produced years of unending scandals in substandard care. I mean, perhaps you've heard about the Kermit Gosnell Clinic in Philadelphia in 2009 and 2010, where Kermit Gosnell, who ironically opened up a clinic in 1973, was indicted for homicides both of women abortion patients and of unborn children who had actually been born alive after abortions and then killed after the abortions. And Gosnell, Dr. Gosnell and some of his associates were indicted for homicides of both women and children. Or to give you another case of Stephen Chase Brigham, who was indicted in 2011 or 2012 in Maryland for similar circumstances in his own clinics. Secondly, there is the growing international data on long-term medical risks to women that the justices didn't have at their disposal in 1973 and really can't deal with as a body that only acts through litigation. I mean, public health officials have emergency authority to intervene in dangerous medical situations, intervene with substandard care in doctors' clinics, but the Supreme Court only acts through cases and only acts passively because the court can't take a case. It can only decide to hear a case that is appealed to it. And so for 20 years, over the past 20 years, the court has only heard an abortion case 3 times. Casey case in 1992, the Stenberg case in 2000, and the Gonzalez case in 2007. Only 3 cases in 20 years. And yet over the last 2 decades, we now see a growing body of international data coming out on the long-term medical risks to women. There have been more than 125 peer-reviewed studies on the link between abortion and preterm birth after abortion, published in international medical journals from Finland and Eastern European countries, Western European countries, Japan, Scandinavia, and the United States. An article was published earlier this month in Scientifica, which is an online journal that publishes peer-reviewed science and medical articles by Dr. John Thorpe of UNC Chapel Hill. And he basically surveys the current literature on the increase of preterm birth after abortion, the increase of mental health trauma, and the increased risk of breast cancer after abortion. I would encourage you to take a look at it. He summarizes the current data and where it is today in 2013. Third is the growing tension between the court's doctrine, which is very broad in allowing abortion, but in conflict with the growing legal protection in criminal and tort law for the unborn child in the states. I mean, the states, in abortion law, the court said that the unborn child really amounts to nothing. But the states in prenatal injury law, wrongful death law, criminal homicide law, and property law have increasingly held the unborn child, in fact, to not only be a human being, but a person. There are 36 or 38 states now with wrongful death laws that apply to the prenatal death of an unborn child. There are 36 or 38 laws with fetal homicide laws that apply to the unborn child. Virtually every state allows a prenatal injury law or a prenatal injury cause of action for prenatal injury to the unborn child. And virtually every state treats the unborn child as a person under property law. All these are in conflict with what the Supreme Court did in Roe versus Wade, and yet the states have the authority to move ahead in increasing legal protection in these areas. Finally, there's the growing tension between the court's broad doctrine of abortion and majority public opinion. If you look at Gallup poll data annually since 1975, Gallup asks Americans whether they support abortion in no circumstances or in every circumstance or only in certain circumstances. And if you look at that data over 40 years, or at least since 1975, it's clear that a strong majority of Americans support abortion only in certain circumstances. So the court's decision 40 years later is really in conflict with majority public opinion. Well, in 2013, I think that some of the staying power, perhaps much of the staying power of Roe versus Wade in public opinion is based on the public fear that chaos would result if Roe was ever overturned and the issue returned to the public health system or the state legislative system. But you know, the irony is that if Roe versus Wade was overturned today, abortion would be legal in at least 42 or 43 states tomorrow, at least through the first trimester, if not through fetal viability, for the simple reason that there are no working abortion prohibitions in those states. They've either been repealed, so there's nothing on the books, or they are blocked by state court versions of Roe versus Wade. So if Roe was overturned today, abortion would be legal through fetal viability in 42 or 43 states tomorrow. And so though most people assume, I think, that overturning Roe would mean immediate legal and social change, the fact of the matter is that overturning Roe would mean the status quo until state legislatures re-examined the issue of abortion anew. And so overturning Roe really means returning the issue to the state legislative process where, I think, based on the Gallup data, public opinion would be better aligned with public policy. So where are we in 2013, 40 years later? I think there are still compelling questions about Roe versus Wade that have still really not been answered. And given the court's track record, given the public health vacuum, given public opinion, given the legality of abortion if Roe versus Wade was overturned, what justifies the court continuing as the National Abortion Control Board? Why should abortion, among all the public health issues that we face as Americans, be controlled by judges? 40 years later, I think these questions have really not been answered and still need to be answered. And so thank you for having me here tonight, and I hope I've left plenty of time for questions and answers, and I'd be happy to entertain any that you might have. Yes?
Going to be, no, we are recording, so I'm going to be the Vanna and bring the mic to you so that we have it for the recording. But thank you very much for a very thought-provoking presentation about the reality of how Roe came about.
Thank you. My name is Roshana Chin. I was particularly intrigued by your last point. You said that if Roe v. Wade was overturned today, we'd have about 42 or 43 states with abortion still legalized in our country. And one of the reasons for that, I guess one of the benefits we see from that is public opinion would be more aligned with public policy. But for a lot of us that work in the pro-life movement, that necessarily isn't an optimal solution either to simply overturn Roe because, I mean, in my mind at least, you know, abortion is something so egregious and so unjust as to allow it to be legal anywhere would be an injustice. And certainly I can realize the practical realities of wanting to at least start somewhere with overturning Roe v. Wade. But I sort of see these situations as analogous to having, with slavery. There are some free states, some slave states, but eventually that kind of regime won't last either.
Mm-hmm.
So what should be the ultimate goal of the pro-life movement? Should we just be trying to go after Roe, or going to the states, or multi-pronged effort? What are we trying to work towards?
Well, I think you have to start with the fact that judges deciding this issue has not been a good thing, and that the Supreme Court established a standard in 1973 that is way out of line with international standards and way out of line with public opinion, and that the judicial standard, the judicial rule, has to be gotten out of the way, and that you're going to have to appeal to public opinion. And that if you appeal to public opinion and work through the democratic process, you may not reach a result that's perfect. You may not reach the ideal result that you'd like, but the result you'll reach with public opinion being what it is will be much better than the way it is today. And I think you have to have faith that you can work through the democratic process with the reality of the impact of abortion on the unborn child and women, to hope to persuade your fellow Americans that the law has to be more protective of life than it is today. But certainly the hope that judges are going to create a better result is, there's simply no reason to believe that, and you have to hope that judges are going to get it out of the way. Does that answer your question?
Other questions?
You mentioned the emergence of some new medical studies and medical data that that point to some, I would call, policy concerns with the existing rule in Roe v. Wade. And I'm wondering if the court can't overturn it, or if that's not a practical reality now, can the court still be flexible in maybe changing Roe v. Wade slightly from, the arbitrary viability rule to another arbitrary rule that might be more flexible to some new policy concerns?
The court back in '73 could have reached a number of different results. I mean, it could have struck down, for example, the Texas and the Georgia laws and simply said these are too extreme, or perhaps the prohibition on abortion except to save the life of a mother was too extreme. Go back and rewrite these. It could have said that there was a right to abortion in the first month of the first trimester, but no farther. I mean, if most nations of the world today don't allow abortion after 14 weeks, for example. The court could have left it to the states entirely and said there's no evidence of any right to abortion in American history. There's no evidence of any right in the precedents of this court. There's no evidence of any right in the text or history of the Constitution. We're going to leave it to the states. They did that with assisted suicide in 1997. So there was a lot of different results the courts could have reached. Same thing today. There are a lot of different results the court could reach. The court could overturn the decisions, but I don't think it's going to, at least in the short term. I think that's pretty clear. Not in the next several years at the very least, depending upon how the court changes. But the court could give greater deference to the states. It could step back and say the states have greater leeway to regulate the procedure, to perhaps limit the procedure. The court could uphold, for example, Arizona's limit on abortion after 20 weeks. That would still allow 95% of the abortions that are performed, because 90% are performed in the first 12 weeks, and perhaps another 5% are performed by 20 weeks. Obviously, that's not going to satisfy pro-life advocates, but it would be the court retreating. The court could allow the court could, for example, adopt a standard that the states can prohibit abortion when the risks of abortion are greater than the risks of childbirth. So there are a lot of things the court could do. But the court's a passive institution. It only takes cases that are appealed to it. It can't regulate. It can't tell a federal judge or a federal court to design a new case that we can hear. It's a passive institution that has to wait for cases to be appealed to it, and it can't pick and choose what kind of issues it wants to hear. So the court as an institution is not well designed to settle this issue, and frankly, I think it's going to be very difficult for the court to reach a satisfactory solution unless it returns the issue to the states. I hope that answers your question.
In my course, I talk to the students about the question of whether the right to abortion is a right to kill that which is within the woman, whatever we call it, embryo, fetus, unborn child, or whether it's a right to terminate the pregnancy. And you gave us a quote from one of the Supreme Court justices that said that viability is an arbitrary point and that there are many arbitrary points. I mean, that's the very nature of arbitrariness. But it seems to me that the viability rule could be grounded in the idea that the woman's right to terminate her pregnancy trumps the unborn child's right to life until such point that the child could live independent of the mother. And then we would require some sort of induced delivery, but we're not going to allow the woman to achieve her freedom from pregnancy through the killing of a child. We will accept it as I believe you used the phrase in an article a decade ago, a necessary evil prior to viability in order to ensure women's freedom. But once it no longer becomes a necessary evil, we're not going to tolerate it. And that's the logic behind the viability rule. I recognize we've not discussed this, but could you comment on that?
I don't see the court doing that, simply because I think it raises a lot of complex autonomy and privacy issues and medical issues that I don't see the court wanting to settle. And I'm not sure that you would have a state pass such a law that would eventually make its way to the Supreme Court. I think where the states seem to be going now is that they're looking at the Gonzalez decision decided by the Supreme Court in 2007, which upheld the Federal Partial Birth Abortion Ban Act, and they're looking to see whether they can limit a broader class of late-term abortions because of the greatly increased risk of maternal mortality after the first trimester. And given where the court is today, I think you're going to see more states, 10 states now have passed actually a 20-week limit. One is in litigation, the Arizona case, could get up to the Supreme Court later in 2013 or 2014. But rather than the more complicated kind of rationale that you just described, the rationale of these 20-week limits is based on protecting maternal health and the additional rationale of the medical evidence that suggests that the fetus can feel pain at or after 20 weeks gestation. They're based on both maternal health and fetal pain. Those are more simpler rationales than the one you've constructed, and I can't see the court ever adopting a rule that in effect imposes on women some kind of artificially induced manner of delivery. I mean, that was, the so-called artificial womb and transferring the child to the artificial womb. Ethicists and legal philosophers talked about that in the 1970s, but I can't imagine the court ever going there, nor can I imagine a state enacting some kind of imposition like that. So I think that the states are going to look at maternal health issues and look for broader limits on late-term abortions based on maternal health.
Other questions?
I just had a question. Other than the misconception that you mentioned about abortion being safer than childbirth, in the justices' writings that you examined, did you find other policy reasons that came out that they believed in at that time? I know in the pro-choice side they have a lot of their arguments, but I'm not even sure if that was the arguments back in the 70s. And so I was just wondering if there was other strong policy arguments that they made.
Well, besides what you read in the Roe opinion and the Doe opinion itself, there was all kinds of, I think, speculation by the justices during the deliberations. For example, if you get into Justice Douglas's files, you'll see all kinds of articles advocating abortion for psychiatric reasons back in the late 60s and early 70s. But the main reason that Justice Powell and Justice Marshall prevailed on Justice Blackmun to widen the abortion right from the first trimester to viability was simply access. And you see letters going back between the justices that women perhaps might not know they're pregnant before 12 weeks. If you have a 12-week limit, they're going to lose the right. Therefore, we have to expand it to viability because they'll have greater access to the right. So, frankly, they didn't have a lot of. They didn't have an evidentiary medical or sociological record. So, really, a lot of the deliberations was based upon their own hunches and kind of personal experiences. Some of the justices had personal experiences within their own families in the 1960s of unwed pregnancies. Some had some personal experience with back alley abortions, and they really looked to these personal experiences to shape the outcomes and the opinions. That's the kind of reasoning process they went through because there was an evidentiary vacuum. I don't know if that fully answers your question, but they didn't have the international data that we have today about the medical risk. There were very few studies in the 60s because there were very few countries that had legalized abortion. So there were no credible long-term studies, for example, on the relationship between abortion and preterm birth that we have today. There were very few studies, probably not peer-reviewed, not long-term studies, that looked at the relationship between abortion and mental health trauma, increased risk of suicide, for example. There were very few studies then. Today, there are over 100 studies, peer-reviewed studies, showing a link between abortion and mental health trauma. There are studies today now showing a link between abortion and placenta previa after abortion and subsequent pregnancies. That data didn't exist, so they really didn't have a lot to go on. And we have much more data today and 40 years of experience in the U.S. and more experience with Eastern European countries allowing abortion in the first trimester than they ever had back then. And so we live in a different world. Yes?
First of all, thank you very much, Clarke, for coming and speaking to us. In light of what you've just said about 40 years of growing, deepening scientific knowledge, refined technology, in view also of constant pressure over 40 years, sometimes from the executive branch of the federal government, sometimes from the states, sometimes from Congress, and also in view of the change in personnel on the court over 40 years, why has the court been so tenacious about Roe v. Wade? Even very liberal legal scholars criticize it doctrinally. What accounts for this obstinacy?
Well, I think it's a combination of things, but the first is that there are massive constituencies in the United States in political parties, foundations, institutions that are propping the decision up. I mean, there are institutions and forces trying to push it over, but there are a dozen or 2 dozen wealthy foundations that are pushing to prop it up. There's a certain constituency in public opinion that obviously doesn't want to see abortion completely prohibited, and there is also the fact that many Americans see Roe versus Wade as the only defense to any right to abortion whatsoever. The assumption being that if Roe versus Wade is overturned, abortion immediately becomes illegal. I mean, what does it mean to overturn Roe versus Wade? What would that mean? Many Americans think that immediately means some federal law goes back into effect, some national law goes back into effect that prohibits all abortions, 50 state prohibitions go back into effect. I mean, there's this assumption that it's Roe versus Wade or abortions prohibited throughout all 50 states. And so even the understanding of what the decision did and was and means and what its the implications of overturning it means is really confused. If you want to look at the data on this, look at James Davison Hunter's book, Before the Shooting Begins, published by Free Press in 1994. He shows that the public is terribly confused over what the decision is, what it means, and what the implications of overturning it would mean. And there's not a lot of effort to kind of clarify that for the American people. I mean, a lot of people like the confusion and like the implications and the assumption that if it's overturned, abortion's banned everywhere. So it's a combination of issues. I mean, the most recent presidential election showed, the constituency behind the war on women and what that means, and that and I suppose one major factor that I haven't even mentioned is the reliance interest rationale of the Supreme Court in the Casey case. In 1992, as you know, a plurality of the justices, O'Connor, Kennedy, and Souter, said we're not going to overturn Roe versus Wade because women have come to rely upon abortion for equal opportunity in American society. And if they don't have the right to abortion, they can't progress financially and in career and education in American society. And that's not just the opinion of the justices. I think there's a substantial constituency in American society who thinks there has to be some access to abortion for equal opportunity. Public opinion may want a much more restricted right than the Supreme Court has allowed, but I think there's still significant public support or assumptions for that, and so it's all those, I think, together, and it's not simple, and so I think it's more complex than we'd like to think.
I'm not in law school, just so you know. But has the Supreme Court had anything overturned? I mean, we keep saying that, but is that?
Yes, in fact, the Supreme Court has overturned its own decisions more than 200 times. But Roe versus Wade is not the usual Supreme Court decision or case because it is such a political. I mean, advocates support Roe versus Wade because of its results. They don't really care, about this history. They don't care about how the sausages and the laws were made behind the scenes. It's the results. Roe protects a right to abortion, and that's all that is all the concern. And the fact that the Supreme Court might have overturned antitrust cases or due process cases or other obscure legal cases, really can't compare to the political constituencies behind this one decision. And the Supreme Court may ultimately follow public opinion. If public opinion increasingly is skeptical about Roe versus Wade and the right to abortion, maybe the Supreme Court will follow that. I hope that answers your question.
I was
Yes.
wondering, outside of passing a constitutional amendment, is there any other way of getting it out of the justices' hands?
Well, unfortunately, a constitutional amendment is, from my perspective, is even more difficult than persuading the Supreme Court. We've had 27, 28 amendments. Believe it or not, there have been 300, since 1973, there have been 330 constitutional amendments introduced in Congress to overturn the Roe v. Wade decision or alter it to some extent. And only one of the 333 has even reached a vote on the floor of the Senate or the House. That was the Hatch-Eagleton Amendment in June of 1983, which was defeated by the Senate on a vote of 49 to 50. 2/3 actually were needed, so it's not as close as it seems. 67 votes were needed. And that is the one and only constitutional amendment that has ever had a vote on the floor of one of the houses of Congress. So a constitutional amendment is difficult, but personally, I think it's more likely that we're going to persuade the Supreme Court to revisit what it's done and to retreat in part or in whole. And with new information on the impact of abortion on women and on families, I hope the justices will reconsider. Yes.
You've mentioned a lot of wonderful things tonight, and I want to thank you for coming in and sharing these things with us. Kind of off the question, you just sort of maybe led into what my question is. What does it look like, that moment when we have a case going to the Supreme Court? What kind of case would that be? What is the climate like in the states right now? What are the possibilities of us seeing a case like that go to the Supreme Court?
Well, first of all, given what public opinion is today, which is more anti-abortion than Roe versus Wade itself, the states have basically, many states, have basically tried to regulate to the greatest extent that the court will allow. You've got 37 states with informed consent laws. You've got 37 or 38 states with parental notice and consent laws. You've got 10 states now that have enacted 20-week limits that all might be challenged in court. You've got an increasing number of states a large number of states that limit public funding. Basically, to the extent that the court has allowed, many states have moved ahead to regulate to the greatest extent possible. And I think that if the court retreats, you'll see states moving ahead with stronger regulations. And so the states in 2011 and 2012 passed more regulations than perhaps at any time since Roe versus Wade because of the court's 2007 decision in the Gonzalez case, which gave the states greater deference to pass regulations. And so the states, I think, will increasingly move ahead with stronger and stronger regulations and stronger limits to the extent that they can get those through the courts and get the Supreme Court to uphold them. But the court today is very precariously, shall we say, divided, kind of 4-1-4. You've got 4 justices who are opposed to regulations. You've got 4 justices who would presumably approve regulations. And you've got Justice Kennedy in the middle, who provides the 5th vote. And so you've got 5 justices who I think today would approve virtually any regulation that makes medical sense based on medical safety, based on protecting maternal health. I think they would approve virtually any regulation that makes medical sense. But that could change in the next couple of years. This president would name justices who would support the original Roe versus Wade, and nominate justices who would oppose many of the regulations that the states have passed. That could be the future direction of the Supreme Court. It's very difficult to say in January 2013 where the court's going to go. Does that answer your question?
It does, yes.
Yes, sir.
I just in terms of a recent Supreme Court decision in Alabama where they determined that the child while in the womb has inherent protection against chemicals. The women were meth addicts, had the baby. 19 minutes later, the baby died from drug
Yes.
overdose. Would that be a test case in which could move forward to say that there is, say, for saline abortion, things that would assault the child while in the womb would have a precedence to say if that state law stands, that child has an inherent right to life without interference, and could that be a vehicle in which maybe more so than any others previously, or is that just another one of those markers that has been put down by the state that will be disregarded by the Supreme Court?
Well, he's referring to a decision by the Alabama Supreme Court on last Friday, I believe, last Thursday or Friday, in which the Alabama Supreme Court decided 2 cases which held that under the state chemical, I think it's called a chemical endangerment statute, that women could be criminally prosecuted for chemical endangerment to their unborn child during pregnancy. Alabama, because of that decision, now stands with, I think, only South Carolina because of South Carolina's Supreme Court opinion in 1997, which also said that women could be criminally prosecuted under chemical endangerment statute. But it was an interpretation of a state statute, which means that the legislature could revisit that decision and try to change that policy, at least theoretically. The reason why I raise that is because the Supreme Court, the South Carolina Supreme Court decision in 1997 was appealed to the Supreme Court, U.S. Supreme Court, and the Supreme Court denied review. And I assume that the Supreme Court would deny review in this case too, because it wasn't a state constitutional decision, it was a state statutory interpretation. And the legislature could change the chemical endangerment statute and change the policy if it wanted to. And if it's left up to the legislature, I think the Supreme Court might defer to the states. We'll see. It'll probably be appealed to the Supreme Court in the next couple of months, and we'll see if the court wants to touch it. I doubt the court will want to touch it. It's a difficult policy question. I mean, there are basically 3 ways the states can go, or I think have gone. One is to do virtually nothing about drug abuse during pregnancy. One is criminal prosecution, which only very few states have really tried. And a second is some sort of civil containment, which I think the majority of states kind of opt for. But they're all subject to statutory, state legislation, and the states can adopt one position or another. I don't know. I'm not an expert in that area, so I don't know which policies, state policies of trying to discourage drug use during pregnancy. I don't know which state policies are the most effective. I don't know what the data is. But because it's a question of state statute and legislation, which the states can change, I think the court will leave it up to the states.
And there is, of course, United States precedent in a case, the Ferguson case,
Yes.
in which the state had required, as a part of examination of women who were on public assistance, that they provide a urine analysis, which is perfectly sensible during pregnancy for all sorts of reasons, but the results were used to detect drug use. And then women were presented with a choice of go to jail or go to treatment. And it's very interesting because none of the major pro-life organizations briefed in the case, because it presents a grave dilemma. Because if in fact you can criminalize pregnancy by women who are drug dependent, are you encouraging them to obtain an abortion so that they don't provide evidence against themselves through the continuation of the pregnancy with these urine samples? Or do you present them with the option that was presented in that particular case of go to treatment or go to jail? And the court decided the case on Fourth Amendment grounds, that it was an illegal search because women weren't informed of this additional analysis of the urinalysis. So I think it raises all sorts of interesting questions. The Alabama case, of course, was a post-pregnancy prosecution. So it's a different sort of posture. But I think that Clarke is quite right, that it's an interesting and difficult question for people on both sides. The pro-choice side certainly don't want to say, oh, yay, we want drug-induced babies. And the pro-life side doesn't want to encourage abortion.
Yes.
I go back to the question about the health exception, because so far with the line of questioning, we've been talking about overturning Roe v. Wade. You talked about the companion case to Roe v. Wade, Doe versus Bolton,
Yes.
which talks about the broad health exception. And I've done a little bit of research on this, more on the international level, but the international definition of health with the World Health Organization, with the United Nations CEDAW definition of health and things like that, it really is a very broad definition of health too, and that tracks what Doe versus Bolton says, which essentially any statute that has the word health in it essentially is going to allow abortion in any case because health is defined so broadly. So how should pro-lifers approach, should Doe v. Bolton and Roe v. Wade or any of those cases be overturned whenever the trend seems to be, at least internationally? I'm thinking particularly of the case of Ireland right now, which is being kind of coming under intense pressure to change their laws because it only allows abortion, I think, in case of life of the mother as opposed to health of the mother. So in crafting legislation, how should we view health exception? Because I mean, it's very popular to talk about for women's health, women's health, women's health, but if you're going to define it so broadly, it's meaningless really. So what should we do about that? Can you comment on that?
Well, the health exception that was crafted in Doe versus Bolton basically was based on the assumption that there were no risks of abortion. I mean, the justices ignored a significant brief that was filed in Roe and Doe, which cited dozens of articles showing risks, and the court never mentioned it. Just disregarded this brief. But the health exception assumes that there are only health issues from delaying termination of pregnancy, and the justices really have not been faced with the growing medical data, and the growing medical data suggests that termination in the second trimester has significant short-term health risks, risk of maternal mortality, and significant long-term health risks. So there's the data perhaps might force the court to re-examine the question of whether a termination at 14, 16 weeks actually poses more health risks than it does health benefits. And so obviously I think the Doe health exception needs to be overturned itself or disregarded, and that the more complex balancing of whether termination at 16 or 18 or 20 weeks really poses more health risks than it does health benefits. And the court needs to jettison the Doe health exception and engage in closer consideration of deference to the states in light of the growing medical data. So I think the to make a long answer short, instead of enforcing the Doe health exception, the court should defer to the states to weigh the medical data. And the court has, in fact, begun to do that in the Gonzalez decision in 2007, where the 5-justice majority said, in an area of medical uncertainty, the states should have greater deference to enact regulations. And I think that's where the court is going to be going in the next couple of years.
The Pro-Life Center at the University of St. Thomas is not merely pro-life, we are pro-family. And we recognize that ending in a timely fashion is important because there may be babysitters that have to be dealt with. So first, I would like us to thank our very learned speaker tonight. And thank you for being here, because the programs don't exist without people that are willing to come. Some of you may be here because we have applied for Minnesota CLE credit for 90 minutes of general credit. So if there are licensed lawyers here who came for that reason, please make sure that you leave your Minnesota bar number with me so that we can report your attendance so that you can receive that credit. In addition to that, I would like to tell you in advance, on February 7th, the Pro-Life Center of the University of St. Thomas, with the Sienna Symposium for Women, Family, and Culture, will be hosting a lecture by Professor Helen Alvarez, the former spokeswoman for the Pro-Life Secretariat of the U.S. Catholic Conference of Bishops, as well as the co-founder of Women Speak for Themselves on the HHS mandate, a very skillful lawyer who has represented the bishops in front of the United States Supreme Court and other courts, will discuss, does the HHS mandate really benefit women, or does it harm them? And so we hope you will join us on the St. Paul campus on February 7th. Again, programs don't happen without people willing to come. I'm very grateful. Thank you very much, and good night.